Good morning. Please be seated. The Supreme Court of the State of Oklahoma is now in session, and we are presiding this morning for oral argument in case number 120617, Kelly Patrick Donaldson, Appellee versus City of El Reno, Appellant, and State of Oklahoma, Intervenor. The court notes, first of all, I'd like to note the members of the court that are present. I'm Chief Justice John Kane from Pawhuska. To my left, your right, is our Senior Justice Yvonne Cogger from Colony, Oklahoma. To my right is our Vice Chief Dustin Rowe from Tishomingo. To my further right, your further left, is Justice James Winchester from Chickasha. And then the next down the line to your left, my right, is Justice Douglas Combs from Shawnee, and Justice Richard Darby from Duke is next to Justice Combs. And then we have a couple of absences, but on the far end to your far right is our colleague from Tulsa, Oklahoma, Justice Dana Keene. So, I have been advised that Jana Knott will be arguing for the appellant. Also present at council table is Jason Hartwig. And for the appellee, we have Alan Taylor and William Blocker. Also present will be Keenan Hott. And I am advised that the proposed time for the parties has modified this morning. Ms. Knott will have 25 minutes at the commencement and 5 minutes for rebuttal, for a total of 30 minutes. And then I understand that Alan Taylor is now going to be allotted 15 minutes, and William Blocker will be allotted 15 minutes for their total of 30 minutes. Solicitor General West has stated that the intervener, State of Oklahoma, stands on their briefing at this point in time. So, with those appearances announced, do council have any procedural questions before we commence? Very good. Okay. Ms. Knott, you may commence.
Thank you, Mr. Chief Justice, and may it please the court. In 2005, Kelly Donaldson pled guilty to second-degree rape and was sentenced to 15 years in prison. He was ordered to serve 6 years in custody, with the remaining 9 years suspended. Mr. Donaldson was released early and first registered as a sex offender in 2007. He's an aggregated offender and is required to register for life under Oklahoma's Sex Offenders Registration Act. After being released in 2007, Mr. Donaldson was arrested again, and in 2012, his suspended sentence was revoked, and he was ordered back into the custody of the Department of Corrections. He was released again in 2015, and upon his release, he moved to an apartment in Oklahoma City, where he's resided since that time. In December of 2021, Mr. Donaldson inquired with the City of El Reno about whether he could live at 1608 Maroon Drive in El Reno. The department advised him that he could not reside at the property because Section 590A of the Oklahoma Sex Offenders Registration Act prohibits any person registered pursuant to the act from residing within 2,000 feet of a city park. The property line of 1608 Maroon Drive sits roughly 310 feet from the property line of Lake El Reno, which is the largest park owned and operated by the city. Despite being told by the city that residing at the Maroon Drive property would be a violation of the 2,000-foot residency requirement, Mr. Donaldson proceeded forward and purchased the property less than 2 weeks later. He then brought suit in the District Court of Canadian County, seeking to use this court's 2013 decision in Starkey to allow him to move to the residence of his choice, arguing that under Starkey and its progeny, retroactive application of any provision of SORA violates the ex post facto clause. But Starkey only addressed the constitutionality of retroactively applying the level assignment system, which was added to SORA in 2007. In that case, when Mr. Starkey moved to Oklahoma in 1998, SORA required him to register as a sex offender for 10 years. Mr. Starkey's 10-year registration period was set to expire in 2008, but just prior to its expiration, the Department of Corrections assigned him a Level 3 designation under the new risk level assignment system and advised him that he would be required to register for life. This court held that the level assignment system could not be retroactively applied to extend SORA registration under the ex post facto clause of the Oklahoma Constitution. The concern expressed by the majority in Starkey was that with regard to the length of the registration, the legislature had continued to move the finish line. But unlike Starkey, this case isn't about lengthening Mr. Donaldson's registration. He's known since he was convicted in 2005 that he will have to register as a sex offender for life. The Attorney General's filed briefs in this case asking this court to overrule Starkey. Although the city agrees that Starkey needs to be revisited, even if this court doesn't overrule Starkey, the city still wins this case because it's distinguishable. Under the framework set forth by the U.S. Supreme Court in Smith v. Doe and adopted by this court in Starkey, the court should ask the following questions to determine whether the residency requirement can be retroactively applied under the Oklahoma Constitution. First, did the legislature intend for the residency requirement to apply retroactively? Second, did the legislature enact the residency requirement as part of a civil regulatory system or to punish the offender? And third, if the legislature intended to enact a civil regulation, are the effects of that regulation so punitive as to prevent its retroactive application? As to the first question, Section 590A states that it applies to any person registered pursuant to the Oklahoma Sex Offenders Registration Act, indicating legislative intent to apply the residency requirement retroactively to all persons currently registered under SORA, regardless of their date of conviction. As additional evidence of legislative intent, when the residency requirement was originally enacted in 2003, it grandfathered in homes acquired or owned prior to the conviction of the sex offender, again indicating legislative intent that the provision should apply retroactively to persons who had already been convicted and who were already registered prior to 2003.
On that point, you have asserted in your brief that Mr. Donaldson is prohibited from residing in this property because it's 310 feet within 2,000 feet, correct?
That's correct.
But you also say that he still can go to the park, right?
Yes.
You have argued that he could enjoy the benefits, I think it's on page 14 of your brief, that he may enjoy the amenities that Lake El Reno provides for its citizens. How do you get around or explain Title 21, 1125, the zone of safety requirements, which requires that a person who's an aggravated sex offender cannot loiter within 500 feet of any park, child care facility, and that any person who has done that is guilty of a felony, 2 years of first offense and a fine, 4 years of second offense, and I assume you can aggravate and enhance and go up probably to 20 to life. Isn't that punitive?
Well, I think Title 21 is obviously not part of the Sex Offender Registration Act, but I would say that loitering and going to the park to play with children or your family are two different things. So, for sure.
He can't do that. There's no exception in Title 21 for his own children. And the purchase of the property, he can purchase the property. He can't reside in that property.
That's correct. He's prohibited from establishing a residency.
There's an Attorney General's opinion that answered that very question from Attorney General Edmondson that dealt with and defined that the restrictions that allowed you to continue to own that property meant that you could own it, but you couldn't reside there. I suppose you could be a landlord, but with the other provisions in Title 21, you can't even go to the property that you own. How is that not punitive?
I think you can go to the property that you own under Title 21. You can't go to the park, loiter around the parks, the schools, the daycares within 500 feet.
The Attorney General's opinion, this is 2005, 11, decided in March 31st, 2005. Paragraph 8. The plain meaning of the statement that deals with disposal of property is that the statute's residency restriction does not require a person to divest himself or herself of any property that was held prior to the conviction. It does not ban a registered sex offender from owning or possessing the property within the protected area. It's simply, it bars them from being present on the property within that 2,000-foot restriction.
So I think those are consistent. I think that's consistent with what's in Title 57. He can own that property, but he can't establish a residency there.
It's all based upon his aggravated status as a sex offender under the Sex Offender Registry Act. Do you agree with me?
I agree.
Okay. And this makes it a felony for him to loiter on that property that he has purchased.
Yes.
Correct? Okay. All right. Thank you.
Mm-hmm.
What legitimate governmental interest might be furthered beyond punishing the offender?
So this is the factor referred to as the most important factor by the Smith Court in the U.S. Supreme Court. Obviously, there's a stated legislative purpose here of protecting public safety. And so the information from the Sex Offender Registration Act is disseminated to help law enforcement be able to easily determine where sex offenders are living. That helps with other public safety aspects of this act in investigating crimes, making sure that if there are aggravated or habitual offenders that are living in the area, the statutes allow law enforcement to notify churches or daycares, things of that nature. So public safety is the stated purpose here of the legislature.
Thank you.
Sure.
Sorry, I didn't know we were doing the back and forth. Okay. Based on these questions, especially the Chief's questions, did you or anyone even argue what you consider or just stated as the most important factor at the district court level? Was there even any evidence presented about the punitive nature of this restriction?
No, there was no evidence presented. This is up on a summary judgment motion, and this was
right. So wouldn't it? So there was. The answer is no. There was
That's
not
correct.
any discussion or argument because the judge just made some kind of legal call saying no. Under Starkey, we're done. Correct?
That's correct.
Okay. So would it be a little premature for us all to be discussing whether something's punitive or not when there hasn't been any evidence considered by a trial court to make that determination?
I don't think so, Your Honor. I think Mr. Donaldson filed his motion for summary judgment specifically on the legal issue of whether Starkey extends to the facts of this case. It was his burden as the person challenging the constitutionality of the statute to prosecute this case in a way that prepared a record for this court as far as the evidence goes. For an example, Shaw versus Patton from the 10th Circuit that was decided in 2016, that case actually went to a bench trial, and there was evidence presented from both sides there as to the punitive effect of this particular residency restriction. And after a bench trial, that went up on appeal, and with a full record of evidence, the 10th Circuit said even that the evidence he'd presented wasn't enough. So I think he had his opportunity at the district court to make a record on the punitive effect of this residency restriction. He failed to do that.
Okay, I have another question. I know that your first argument is to overrule Starkey. Would you agree with me or disagree with me that Starkey adopts the Smith v. Doe test completely? I mean, I'm not talking about how they applied it or what the final ruling was, but the actual Smith v. Doe test was applied or adopted by this court in Starkey.
The court did not adopt the clearest proof standard that the U.S. Supreme Court adopted in Smith versus Doe.
All right, making the assumption that the very last sentence in the conclusion with the argument of what clear proof is or is not, two things. One, I understand one argument is they didn't flat out say it's a civil remedy, which I think is wrong. Two,
I agree.
We can argue whether or not that's your burden was established. But besides those two arguments, which I'm having you leap to a big assumption, in general, we are looking at Smith v. Doe's test in regards to these type of statutes. Would you agree? Okay. And then, can you tell me if Starkey just stands for, well, the levels at the time cannot be retroactive because they're punitive, right?
That is the holding in Starkey.
Right. And you would also agree that in Starkey that they said, we're going to look at all these other restrictions, but we're not going to make a decision on whether those are punitive today, correct?
I agree with that.
And then they say, the majority says, well, since we're not making a decision on that, we're just deciding that the levels are punitive. It leaves the door open for this court to later decide whether these other restrictions are punitive or not.
I agree.
Okay.
And
so again, we're here to decide at the end of the day if that is all correct, without even overruling Starkey, that if that's what it stood for, that we can then be faced with, if there's any amendments coming up, whether or not that specific amendment is punitive or not, and then whether or not that amendment is retroactive without overruling the basic test in Smith v. Doe.
I agree with that, Justice Keene, and I want to be clear that my first position is not that this court needs to overrule Starkey in order for my client to win this case. We think that Starkey is distinguishable, and that's why we applied the language of the statute, because this court has not said that we can't retroactively apply the residency restriction. That's not been a holding of this court. And of course, the 2019 opinion from the Court of Civil Appeals is not binding on anyone except the parties in that case. And so our position is that you don't have to overrule Starkey. I agree with you that there are some things in that opinion that we think should be clarified, especially that this is a civil registration system and that the standard that this court should look to use is the clear proof standard, because that aligns with this court's standard that it uses when constitutional provisions are challenged. You have to show that they're clearly, palpably, and plainly inconsistent with the Constitution. That's a very similar standard to clearest proof standard. So those are the two things that we would ask that the court revisit and potentially clarify, but the court doesn't have to overrule Starkey for the city of El Reno to win this case.
All right. I think I just have one more question. Well, I'll hold off on that one. Thank you, Chief. I'll wait for a moment.
There's evidence in this record. In 1972, the city passed an ordinance creating Lake El Reno as a park, and that's been on the books since that time. That wasn't challenged here by Mr. Donaldson, the validity of that 1972 ordinance, and of course, that's what governs municipalities, is validly passed ordinances. So in our view, that's not an open question, and our record establishes that Lake El Reno is a park.
My other concern is, as I understand the statute, Mr. Donaldson could buy a house, and it would be in a place where it was not close to a park. But then if a daycare center wants to move next door, it can, under the statute, and he doesn't have to move.
That's correct.
Which doesn't make any sense if the purpose is to protect these children.
I agree.
It does not make any sense. It's not rational.
Well, I think that the legislature, with that protection, and then the protection I mentioned earlier, which was if you had owned or acquired your home before you were convicted, you essentially get to keep it. I think those act sort of as grandfather provisions. And as this court noted in Starkey, there's a case from Kentucky and a case from Indiana where there were no grandfather provisions at all in those statutes, and in those cases, those residency restrictions were struck down. And so I think the legislature here is trying to find that balance between no grandfather provisions at all and all of the grandfather provisions you could include, which defeat the purpose of the public safety aspect of protecting the children. And so this feels like a little bit of a middle ground. But I don't disagree with you, but there is some legislative line drawing, I think, that has to happen here. Otherwise, this court's going to say, there's no grandfather provision, this is punitive.
Thank you.
Counsel, much of the discussion this morning is on the punitive nature of the statute. But in order for the defendant or Mr. Donaldson to prevail, punitive has to be shown, but also that it's retroactive, correct? Mm-hmm. So it's not just punitive, it's the retroactive application of the punitive statute. What's the city's position on both punitive and retroactive? Do you stipulate that it's punitive? Do you stipulate that it's retroactive, or neither? Is the statute punitive? You say no?
The statute is not punitive.
Is it retroactive?
Yes, we believe so.
How so? How is it retroactive when it says it doesn't apply if he owns the property at the time the statute's passed? It's prospective in that sense, isn't it?
I read that provision, I'm assuming you're referring to the provision that says if he was convicted and he owned the home before that, he gets to essentially keep the home.
Well, the statute, when it was amended in 2021, when it added parks, it said establishment of a park in the vicinity of a residence of a sex offender will not require him to move. And you say that's retroactive. You stipulate that it is retroactive despite this language.
Yes, I think it's retroactive because I think where 590A says that it applies to any person registered pursuant to SORA, I think that means any person registered, whether it's you started registration yesterday or you started registration in 2002 when you came out of Department of Corrections. And I think there's other language throughout SORA. That particular provision, any person registered pursuant to SORA, is used at least 10 times throughout the statute. And there's only 2 other places where the legislature uses a date to delineate that we want something to apply prospectively from this date. It's in the aggravated and habitual offenders provisions of the statute. And they say after November 1, 1999, if you're convicted of these crimes, you're considered an aggravated offender. So that to me indicates the legislature knows how to draw that line to say prospective only, but when they use the language like any person registered pursuant to the act, they're talking about any person back to 1989 when the act was originally enacted.
If this is a fair statement as to what you're arguing, first of all, is whether it's punitive or not. Would you agree with me that the effect is punitive? It's something that none of us would wish for. It's at least an inconvenience to this gentleman. But the intent of the legislature is to protect children, help law enforcement. It's not to punish the individual. Is that what you're arguing? And if that's not what you're arguing, is that a fair statement?
I agree that the intent of the legislature is to protect children with this particular residency restriction. I don't agree that it has a punitive effect. I think that's where you have to take a look at those factors.
Would you like for that to be affect you personally? Certainly not. No,
I would not, but I'm not a registered sex offender.
I know you're not, but that's why it has a punitive effect.
Well, I think that's why it's important for the court to actually go through those factors and see how this stands up to each one of those. Because when we're talking about banishment, which is what this court referenced in Starkey, when you really take a look at that, it doesn't play out here. Historically, when criminals were banished as punishment, they were sent away, expelled completely from their communities. They weren't allowed to even enter the jurisdiction. Here, that's not the case. Mr. Donaldson can live in El Reno, he can work in El Reno, he can visit El Reno, so that banishment analysis doesn't really hold up when you're talking about, is it a traditional form of punishment? And then as you work through the rest of those factors, I agree that there could be some inconvenience here, but not under the facts of this case. He bought this house in El Reno after the city already told him that this was in a restricted area. We've not gone to his house and said, sir, you've lived here for 10 years, but now you're in violation of the statute and you need to move.
And that move obviously doesn't reflect well on this gentleman, but that shouldn't turn the key here. That shouldn't be why we make a decision, should it?
Well, I think that is part of the issue that we have with Starkey and whether it is thwarting the legislature's intent to protect public safety. It's because not just this case, but the Graham case from the Court of Civil Appeals, in that case, the sex offender was convicted in August of 2014. Then the legislature went into session, enacted an amendment to add HOAs to the provision. The governor signed it in May, and then he buys a house within 2,000 feet of an HOA park and signs the deed 3 days before November the 1st, and then sues the city of Norman and says, I can live here because Starkey controls under the date of conviction rule. And that's doing exactly what the legislature is trying to prevent here in protecting children. I mean, Mr. Donaldson, in a big picture view here, was convicted of raping a minor under the age of 14. The person exactly in the legislature's mind that we're trying to protect here, and now he wants to go live within 300 feet of a park. The other area the legislature has said is off limits because children congregate there. This is, I think, the exact situation that they were concerned about, and he's using Starkey essentially as a sword when I don't think that's what Starkey did. I don't think that's what Starkey held. It can be limited to its facts. The 2007 level assignment system is what Starkey said couldn't be applied retroactively. And I think as we move forward, the court's going to have to take a look, just like Justice Keene said, at each of these registration requirements, compare them to these factors against the evidence in the record that has or hasn't been presented, and determine if they have a punitive effect. And here our position is that it doesn't rise to that level.
Thank you.
Now, Ms. Knott, I think you distinguished Starkey correctly when you say that what we determined in Starkey was that under Oklahoma's Constitution, changing the duration of time from a term of years to lifetime was an unconstitutional ex post facto punitive move. But haven't there been a score of other courts that have looked at residency requirements and found that they are not punitive? And specifically, are you familiar with Shaw versus Patton,
Yes.
the 10th Circuit's analysis of this?
Yes, and my time is up. Can I continue?
I would request that I think we all have more questions, so
Okay,
we'll
thank you.
continue with those. So the 10th Circuit acknowledged our ruling in Starkey and said that under the Oklahoma Constitution, we can do as we have determined justice requires, but that under the federal Constitution, they independently analyzed specifically a residency requirement and determined that under the 5 factors that it was not punitive. Is that fair?
That is fair, yes.
All right, and I believe the U.S. Supreme Court in Smith versus Doe, 2003, same conclusion?
That was not a residency restriction, but yes, they analyzed Alaska's sex offender registration system in total to determine if it could be applied retroactively to someone who was convicted before that system was enacted. And so that was the fact pattern in that case. Justice Kane, I think it's pretty clear across the board that a majority of state courts And all of the federal appellate courts have concluded, the federal appellate courts are unanimous that SORNA, the federal system, can be applied retroactively, and a majority of state courts have said that their systems and these individual requirements can be applied retroactively. So respectfully, I think this court is in the small minority with the decision in Starkey, but again, it can be distinguished if the court, thinks that this situation is different than what they were faced with in 2013.
But counsel, it really doesn't matter, because we can provide greater rights under the Oklahoma Constitution.
I agree, and
it doesn't matter what the other states say.
I agree.
Or the United States Supreme Court.
I agree with that. What I would say is that there wasn't any reason given in Starkey as to why the Oklahoma Constitution, the ex post facto clause in our Constitution, which is the same wording as the federal Constitution, would give sex offenders more rights under that clause than does the federal Constitution. There wasn't any historical or textual evidence provided as to why we would essentially lower the standard of proof. I think that's where Starkey differs, and that's how you get to a different standard in the Oklahoma Constitution, is we're talking about the neutral evaluation of the factors under Starkey, whereas the U.S. Supreme Court said the clearest proof is what's required. I think that difference in that procedure is where the Oklahoma Constitution grants them more rights, and I'm just not sure it's justified under the text or the history of that provision.
Well, right now it is, because we said so, right?
I agree.
And as you stated, we expressly did not opine on the specific residency requirements that's before us today.
That's correct.
All right, and to clear up something else in my mind, you made reference to a 2019 Court of Civil Appeals opinion. Was that Graham versus Carrington Place? Is that the
Yes.
ruling you're referring to?
Yes.
All right. Thank you.
It's not, I'm going to go back to when Justice Rowe asked his question. It made me think of another. I was interested in his question, but can you tell me if you know or if you have an opinion on when courts are facing this decision? We have, of course, punitive decision and retroactivity decision, but doesn't one come before the other? If it's punitive, it can't be retroactive, and we know that. If it says that it's not retroactive, that's easy. But if it's not clear on retroactivity and you're trying to determine punitiveness, if that's a word, which one is first? Is there a chicken before the egg argument, or do you have to decide punitive, and then if it's not punitive, then you decide retroactivity? Do you have an opinion about which one you do first, or does it matter?
Sorry, I think the first step is prospective versus retroactive, because if the court says this is a prospective statute, I don't think you have to get to the issue of whether it's punitive or not. I would say that the City of El Reno has applied this statute to Mr. Donaldson retroactively. So even if the court finds that the intent wasn't to be applied retroactively, there is still an as-applied challenge here because we've applied it to him. And so we think that under an as-applied challenge, he hasn't put the evidence in the record to show that it has a punitive effect on him, and we would at least win on that limited basis as well.
Thank you.
Any other questions? Thank you, Counselor. We appreciate that. All right. I'd like to hear from the appellee at this time. Or pardon, appellant, Mr. Donaldson's counsel. Oh, no, I had it right the first time.
Thank you, Chief Justice, Justices, and may it please the Court. My name is Alan Taylor, and I am joined here this morning by William Blocker and Keenan Hott, and we represent Appellee, Mr. Kelly Patrick Donaldson. Mr. Kelly Patrick Donaldson respectfully asks this Court to follow Starkey and its progeny and uphold the district court granting of summary judgment in his favor, finding that the retro application of Section 590 of SORA is in violation of the Oklahoma Constitution.
But are we following Starkey with this ruling, Counselor? Let me read to you a direct quote from the Starkey opinion. Again, we are not making a determination of the constitutionality of any of these individual registration requirements, but for purposes of analyzing the second Mendoza-Martinez factor, we find the totality of these requirements weigh in favor of punishment.
Yes, Your Honor. When in Starkey, this court looked at SORA as a whole, and when looking at it as a whole, and yes, Starkey was focusing on the retroactive application of the registration requirement itself, but this court looked at SORA as a whole. And when looking at SORA as a whole, when you go through the Mendoza factors, it is clear that this is punitive, and it outweighs any sort of the limited, I guess you could say, in what I believe is that the state's state's intent to protect children. So I do believe that Starkey and its progeny, when being followed, would limit the retroactive application of the residency requirement in this state. And I apologize, Your Honor. I'm going to discuss with this court how it correctly reviewed Smith and the application of the Mendoza factors in determining the overall effects of SORA, and that it, yes, Judge.
These microphones are so bad. Can you please, really talk into the mic or move it towards you a little bit? I just want to make sure I hear your argument. I'm sorry for interrupting, but I want to hear you.
I'll get a little closer.
Oh,
is that better?
Yes, thank you.
And then Mr. Blocker, he will go more in depth with Starkey and the development of its progeny and how applying Starkey and its progeny to the case at bar, that he will show that Starkey is workable, and those can be applied in this case as was at the district court level. Now, Appellant has asked this court to revisit Starkey and find that the clearest test should be applied when interpreting whether the effects of the 2,000-foot residency requirement are so punitive to prevent retroactive application of Section 590. Appellant says they rely on the majority opinion in Smith v. Joe. In the majority opinion, the court said that only the clearest proof would override legislative intent and transform what has been deemed a civil remedy into a criminal penalty. This is where Appellant has missed the bar. One, Smith v. Doe was a very slight majority in that case. There were 4 justices that came to the same agreement on that the clearest proof should apply. There was justice that had concurred and was concerned with the majority's extensive look at how it was being applied outside the face of the statute, and said that the court should look at the face of the statute when determining if it's an ex post facto law. Then there were 2 concurring opinions that only concurred in judgment, but were not real clear on the clearest proof test if that should be applied. And in that case, Justice Soter said that the heightened burden of the clearest proof test should only be applied when the evidence clearly points in a civil direction. If not, and if there is no clear intent, then the overall effects test should be evenly weighed. And then, as Justice Thomas pointed out, the ex post facto inquiry is accomplished again by examining the whole statute on its face. And here, this court, it did adopt the clearest proof test, and it also looked at the dissent. And in the dissenting opinion, the justice said, again, we have to look at the face of the statute and what is the intent that is on the face of the statute. And And it's not clear, even when you're reading the majority opinion, whether they believed that the clearest proof test would be applied if the face of the statute itself showed an intent for punishment rather than civil. And in this case, it is clear that Section 590 of SORA, if taken as a whole, is punishment. For example, Your Honor, when Mr. Donaldson was convicted, all that he was limited to was a 2,000-foot radius of a private school site or an educational institution. And violating that, he would only be guilty of a misdemeanor the first time with up to a $3,000 punishment. Any second or subsequent offense only be found guilty of a misdemeanor with up to 1 year in county jail. However, today, the legislature has added a laundry list of places that, Mr. Donaldson or anybody who was previously convicted of a sex offense where they wouldn't be able to live.
You're not arguing any of those. You're only arguing where he bought his house.
That's correct, Your Honor. So when looking...
Okay, that's fine. That's all you're arguing. But I have a quick question.
Yes.
Ms. Knott said, and just so you know where I'm going, I'm going to ask you about retroactivity and punitive, and which one you think she thinks we decide retroactivity, and then you can look toward the punitiveness of the statute. Do you agree with her on those two things? That you look at retroactivity first, and then whether or not it's punitive?
Yes, I would agree with that,
Okay,
Your
tell
Honor.
me why it is not retroactive for your client.
It is retroactive because in the statute, it says on its face, it is unlawful for any person who is registered pursuant to SORA to be at, and again, the laundry list of places. So it would be applied on the face of the statute retroactively, yes,
Okay,
Your Honor.
thank you. And then if we go to the punitive, which I think you're arguing here today, is a really interesting argument. Do you think that you would have the burden of proof to prove that it is punitive?
Yes, Your Honor.
Okay, and if you do have that burden, do you think that do you agree with Ms. Knott that you've lost your chance to make that argument by not raising that below? Or do you think that that was closed out by the trial court ruling on the law and then not opening it up for evidence? What's your thought about that process?
Yes, Your Honor, I don't believe that we had gotten to the point where that would apply. The Mendoza factors were discussed in the summary judgment.
Wait, they were?
Yes, Your Honor.
Okay, I just couldn't hear
yes,
you, I'm sorry.
And they were also discussed in the briefs to this court, but we don't get to that. I think there's there's a second, first being, is it retroactive application? And then the second part would be, we have to see, is the intent to impose punishment? Because if the intent is to impose punishment, that ends the inquiry, and you wouldn't even get to the Mendoza factors to start weighing whether the scheme is so punitive in either purpose or effect to negate the state's intent. And when applying Starkey and its progeny below and looking at the evidence that was applied and looking at the face of the statute, Your Honor, or Your Justice, it is punitive on its face. Again, looking at Section 590, the appellant asked this court to just look at the 2,000-foot residency requirement in that statute. That's not correct. That's not looking at the face of the statute. In addition to that 2,000-foot residency requirement, there are also criminal penalties. Again, at first, when Mr. Donaldson was convicted, the fine was $3,000 to start with. It's much higher now. And now, in the beginning, it was a misdemeanor. If he violated this, it was a misdemeanor. Now it's a felony. 3 to 5 years for subsequent offenses. And in addition to that, as Justice Combs, as you pointed out, and the criminal statutes say nobody can be loitered within 500 feet of a park, and that's nobody. That doesn't have any sort of exceptions on it. Now, the appellant stood up here and explained to this court that the purpose was to protect children. And when you look at the stated purpose to protect children, that makes no sense. And it's exceptionally extensive in this case. Because if the purpose was to protect children, as Mr. Combs and Justice Darby, I believe you pointed out, there is a laundry list of exceptions. One being if you owned it before, you can still own it, even after the statute was passed. If a daycare facility or a park gets built beside the sex offender, you can still live there. If this purpose was the stated purpose that the appellate wants you to believe is the actual purpose of the legislature's intent to protect children, why did they allow for all these exceptions? And why didn't they limit it to look at who, what, when, and where, why? They don't ask, okay, well, what was the sex offense for?
But counsel, do you agree with me that it's the legislature's job to develop policy and not this court?
Yes, it is.
Okay, and then if so, listen, you know, these briefs in these cases just kind of shock me sometimes when they're like, yeah, you can't have a house by the park, but you can go hang out there all day. How is that helpful to your policy argument, right? You agree?
Yes, I do, Your Honor.
Okay, but at the end of the day, if the legislature could, don't you think they would say, well, sex offenders have to live on this little island away from all children and all contact from children, but we all know that that's completely unconstitutional. Don't you think they probably would do it if they could?
I do believe they would do it if they could.
So then they come up with these other little policy restrictions to try to curb what they think is for children's safety, correct? And even though some of us might not think that they make sense, they might not then be unconstitutional. Is there a difference that we just think they're silly versus unconstitutional?
No, Your Honor, and Appellee didn't ask for the court below, nor is it asking this court to find any of the SORA unconstitutional. SORA itself is constitutional, and Appellee would concede that. And we would also concede that it is the legislature's purview to look at policy and determine what this state believes should and shouldn't be done with sex offenders and protecting children. We would concede to that as well.
Because it doesn't make sense to say the coyote can build a den next to the hen house, can't live there, but can go visit it at any time they want. Exactly.
And it is this court's purview, though, to look at the retroactive application of that. And when doing that, as we were first discussing, Justice Keene, you first look at what is the intent of the statute. So as you were discussing, some of that doesn't make sense, that you can't buy a home next to a park, but you can live in a home and a park can be built next to you. That's fine. Well, that negates any sort of, or belittles the stated intent to protect children. So then when you look at the statute on its face, it's clear that it's punitive in nature. Therefore, it being punitive in nature, this court would need to go no further. However, if this court does seem fit to go further, then that's when you would look at the retroactivity. Maybe is it being retroactively applied? Again, this statute says it is to be retroactively applied. And then the Mendoza factors, that's when you would get to that point. And below, the Mendoza factors were looked at and they were argued to this court, and it's clearly punishment. I mean, if this court uses the clearest proof test, this is punishment. It is banishment.
Counsel, if that's punishment, is it punishment that a marijuana business cannot be within 2,000 feet of a school, or a tattoo parlor has restrictions, mobile home parks have zoning restrictions? Are those punishment?
Those would be distinguishable, Your Honor.
I'm sorry?
Those would be distinguishable, Your Honor.
Well, if a marijuana business cannot be located within 2,000 feet of a school,
yes.
Do we have to look behind that law and see if there's a rational basis before we determine if that business owners being punished? Isn't that the same argument you're making here?
No, Your Honor. I see my time is about to expire.
Go ahead.
Can I continue? Yes, Your Honor, I believe it's distinguishable on two fronts. One, you're talking about a business. And in this case, in any sex offender registration case, we are talking about a person. We are talking about a person's livelihood. We are talking about somebody who isn't being looked at for what crime they did, but being wholesale, not allowed to live in, certain places. For example, if somebody was convicted of a sex offense with, just outside of the Romeo and Juliet law, they could be held to the same standard as somebody who was convicted of, let's say, raping their own child who was 2. Those people are stuck to the same exact standards, and that doesn't make sense. So that is distinguishable, Justice, but it's also distinguishable because you would look at the retroactive application of that. But when you're talking about, for example, marijuana grow, that's completely civil in nature. That goes through OMMA, and OMMA looks at that and provides civil penalties. There are limited civil penalties, but there are a laundry list, and every single statute in SORA has criminal penalties, Your Honor, just going to show more that this is punishment, not a civil regulatory scheme.
Well,
Would you agree with me, counsel, that if the argument is that under the Sex Offender Registration Act it is not meant to be punitive, there's no intent for the legislature to make it punitive, the legislature, in not making that punitive, SORA, punitive, has gone around and under the Safety Zones Act and Title 21 made the same activities punitive and a crime? In other words, they're doing what they didn't do in the first hand, they're doing it on the backside. Can we look at that to determine whether or not what the overall legislative intent was? Do you agree or would you disagree?
Well, first, Your Honor, I would disagree that even the stated intent or the intent when looking at the face of especially 590, that it's non-punitive. I mean, it is punitive on his face, and it even becomes more clear when balancing the Mendoza factors that it is punitive. But yes, they have gone a backdoor. That's exactly what the legislature has done. This court said, our Constitution matters. We give little care to what the United States Constitution says. We care about our people, and we care.
If I can, I want to interrupt you because I want to ask another question. Ms. Knott talked about banishment. You did not provide at the trial court level any evidence with regard to Canadian County as to where a registered sex offender can or cannot live, did you? There's nothing at the trial level that gives us any indication. If you look at a geographical map with circles where you have parks and daycares and homeowners associations and zoning restrictions like they've done in other cases, 10th Circuit or the Iowa Federal Action, I think, or the 8th, I believe it's 8th Circuit, talked about that. You didn't present any evidence with regard to that, did you?
No, Your Honor. With the evidence that was provided was, and I believe my co-counsel will discuss more about this, was what the city has labeled a park. They say the city of El Reno has called the entirety of the lake a park, and I don't understand how that...
The park in this case doesn't cover the entire county of Canadian County, does it? Or El Reno?
No.
The city of El Reno? So, but there's you haven't presented any, my point is, you didn't present any evidence at all with regard to a banishment argument that there's nowhere within El Reno or nowhere within Canadian County where Mr. Donaldson can reside legally. You didn't present any evidence with regard to that at the trial court level, correct?
That is correct. However, I would point out that Appellant, in her own motion for a response in the motion for summary judgment, pointed out very clearly that Mr. Donaldson could leave El Reno and could go live wherever he wanted. I mean, I think that's clear on the state's, more evidence on the state's intent that
and I assume you take that to be banishment from the city of El Reno.
Yes, Your Honor.
Okay, thank you. That's all, Chief. Thank you.
Okay, Mr. Taylor, I want to make sure that we're not confusing or conflating a burden with a punishment. Now, isn't it true that the state can take action against a particular citizen by statute that is a tremendous burden to that citizen, but it's not a punishment of that citizen?
Your Honor, may I clarify?
Please.
I guess what kind of action is, because the kind of action that would be taken, I mean, that's going to have a huge impact on my answer. For example, if
well,
a driver...
I think the Vice Chief's question was I think a good scenario. Let's say zoning. Can a zoning ordinance be burdensome to somebody that they can't do what they want to do, where they want to do it, on property that they own? Isn't that a burden?
It would be a burden, but again,
but is it a punishment?
if it was an individual, I think they would have to be balanced on, what exactly we're talking about. We're talking about an individual who lives in a home, who wants to live there and reside there with his or her family, and then the state takes some sort of action that would require this person to move or not live in that area. I think that is a punishment. That is the traditional banishment that the Oklahoma Constitution does not take lightly when somebody is banished, and that itself is akin to banishment, Your Honor.
Thank you. Other questions? All right, thank you, sir.
Thank you, Your Honor.
So are you Mr. Blocker?
I am, Chief Justice.
Very good. Glad to see you this morning, and commence when you're ready.
Okay. Mr. Chief Justice, and may it please the court. Paragraph 77 of the Starkey decision says retroactive application of SOAR registration is punitive and outweighs its non-punitive purpose, inconsistent with the ex post facto clause of the Oklahoma Constitution. Starkey does not hold that OSORA on its face is unconstitutional. It just states that the state is prohibited from retroactive applying anything that adds additional sanctions on those who have already been convicted before the legislature increasing sanctions was passed. In this case, the appellant has made numerous arguments throughout this litigation at the trial court level and in the appellate briefs that the appellee presented little to no facts and he made the claim that he was challenging the constitutionality of the statute. It's always been Mr. Donaldson's position and the appellee's position that they're not challenging the constitutionality of the statute because in Starkey, especially in paragraph 60 of the Starkey decision, the court analyzed OSORA as a whole, as Mr. Taylor laid out. In paragraph 60, they specifically analyzed section 590, and this court akined that part of OSORA to be punitive in nature. It was a big part, this particular section, and that's what the court later on, the Court of Civil Appeals, which I understand is persuasive, but we're talking about a lot of persuasive authority today. They relied on the court's analysis of OSORA basically at paragraph 60 of Starkey, and they said that 590 was punitive as well. That is what the trial judge rested on. There was facts presented that were relevant to the summary judgment and that particular issue at the trial court level. There was facts presented that Mr. Donaldson's home that he purchased was not within 2,000 feet of a school or educational site. There was facts presented that even if park was going to be applied, the definition of park is in an error because if you read, and we could get into the statutory construction arguments of what a park is, the court determined that to be moot at the trial court level, so I'm not sure it's ripe for appeal.
I would agree with that.
But they determined there that it wasn't, his house wasn't within 2,000 feet of a playground, it wasn't within 2,000 feet of a swim beach, things that would naturally be there. It's simply not true that he's never attacked, that he's always challenged the constitutionality. What his position is that we were challenging the application after Starkey and its progeny. And this court went on down the line in a number of cases after Starkey to clarify and to reaffirm that any additional sanctions, we keep talking about punishment today, and we're talking about, I apologize, Justice, the word that you and Mr. Taylor were just discussing, burdensome. But this court has said that any increased sanctions should not be applied retroactively. And they've said that over and over again. You have said that. In Burke v. State, this court clarified that, and in Cerniglia. In both of those cases, they were talking about the application of whether, when you moved here, which version applied to you, and any increased sanction would be the one at the time. This court also clarified in Frye that this is not a blanket against ex post facto violations, and I think Frye is a very important case that this court came down with. It clarified that it's not blanket ban on ex post facto. If the sanctions increase, it can't be applied retroactively. If the sanctions decrease, it can be applied retroactively.
Well, we discussed a little bit about the difference between a burden and a punishment, but can't there also be a distinction between a deterrence and a punishment? A punishment being a consequence for a prior act, deterrence being an effort to hope to prevent a future act.
I would agree with that, Chief Justice. I also would believe that when you're looking at that, you have to look at the punitive effect of whatever deterrent you're attempting to use. And in particular, in this case, as Mr. Taylor pointed out, the statute went from a misdemeanor if you violated this statute to now you're going to do a minimum of 1 year to a maximum of 3 years for a violation of the first offense and have another felony on your record. And you're going, if you have a second or subsequent offense, it's a minimum of 3 years with no maximum. So this statute on its face increased its punishment 3 to 10-fold. And I've been involved in cases, I've represented a number of sex offenders across the state of Oklahoma, and I've been involved in cases where they use the predicate offense that put the person on the sex offender registry in the first time to enhance the sentence to make it 5 to 20 years like Justice Combs had alluded to. This is absolutely more than a deterrent, Your Honor. The intent of this statute is to punish. The legislature has done everything they can to go around this court's decision in holding in Starkey. And I think this court has laid out a pretty good framework. What they ask us to revisit it on, and they ask you to revisit their decision, and the state of Oklahoma asks you to overturn yourself on, is based on federal case law that interpreting the U.S. Constitution. And Ms. Knott is a great lawyer, and she advocated very well, and she was relying on Shaw a lot, which is also persuasive authority. But Judge Bacharach, well-respected Oklahoma lawyer and judge of the 10th Circuit, clearly said in that case that he was limiting his decision to the application of the U.S. Constitution as it applied to the facts in those cases, and that Oklahoma had done different in Starkey, and that the Oklahoma Supreme Court was the final arbiter of its Supreme Court. And as Justice Cogger pointed out earlier, you have the right to give Oklahoman citizens more right according to that Constitution than the federal government affords. Yes, yeah, Justice.
Before he bought that house.
Did he know the consequences of the statute that were in the penalty phase? Yes, Your Honor.
He knew it, right?
Yes, Your Honor.
It's not retroactive. He knew it before he did it. It's up to him. And if you're going to say, well, but it can't apply to him and somebody else, of course it can. That's a consequence of his sex offense. Say you up the sentence for a second-time felony offender, that affects different individuals differently. It's ultimately up to him to abide by the law as it applies to him, is it not?
Your Honor, I would respectfully disagree that it is prospective in intent, because the statute at the time that Mr. Donaldson agreed to accept a plea in this case in Woodward County, the statute didn't have those penalties in it. And it didn't have those restrictions in it.
Given, sure. But that's not what he's being, that's not what he violated this time. When he entered his plea, there's a new restriction. And he knew what it was. He was told. He was supposed to know on his own, but he was told anyway. He said, I don't care, I'll do it anyway. Right?
No, I would disagree, Your Honor. He actually bought that house and filed suit seeking declaratory relief under the law. He did not subject himself to those penalties because he was smart enough to seek relief from the court based on this court's precedent.
That's not really his call, is it?
I believe it was his right as a citizen, Your Honor, to seek relief from the court system.
Sure, no doubt about it. Maybe he's right, maybe he's wrong. I guess we'll find out.
Okay. I believe that stare decisis is really important, and there's been a recent flu in other courts, but this court has always maintained a very strong adherence to stare decisis. And when you look at this case and how this court has came down since Starkey, it has been consistent.
Haven't all those cases been about levels? I don't know of any case that we've talked about any of these restrictions until now. Are you trying to tell me there's another Oklahoma Supreme Court case that talks about a restriction outside of Starkey and the level requirements?
No, Your Honor, I wouldn't say there's one that talks about the restrictions.
Okay, if we haven't done that, then I really want to understand this stare decisis argument. Because that's why I asked, it's not the same questions. Starkey's test, what legal test in Starkey do you not agree with? You agree with it all, how the test, the Smith veto, how they lay it out, the factors they considered. You just don't want the argument to be, your stare decisis argument is, don't flip the outcome that it's punitive. You don't have any problem with the legal test in Starkey, correct? The Smith veto factors. We should continue to follow Starkey there, correct?
I agree, Your Honor. I'm not sure that I would agree that in this case, looking at this case and this statute in particular, it's punitive on its face, and I think you don't need to go as far as going through the Mendoza factors. But even if you did, I think they still weigh down that this is punitive in nature.
So are you trying to argue that, I just want to make sure I understand, that Starkey stands for you automatically win because it determined that this restriction was punitive?
No, Your Honor. What I'm saying is that the test that the Smith court alluded to, and I don't think the Smith court is quite as clear as Mr. Taylor laid out. There's a number of concurring and dissenting opinions in that case. And in that case, they first said, if it's punitive, you stop. There is no reason to look at an intent and effect test. If it's punitive, it's over.
Right.
Retroactive application is stopped. And in this particular statute, this court evaluating it today, if you look at the statute, it's punitive in nature on its face. Mr. Donaldson could suffer a felony, a subsequent felony, for 1 to 3 years, the first offense. The second offense, he could suffer minimum of 3 years up to life, Your Honor. I also think it's important as a fact that
Wait, but those felony criminal punishments are in this civil statute?
Yes, Your Honor.
Okay, so that's why we should consider the legislative intent behind those, because that makes it punitive.
Yes, Your Honor, I believe.
Thank you.
I also would like to point out to the court is Mr. Donaldson has never, and I think Justice Ginsburg in the case that we're all talking about in Smith that led to Starkey, Justice Ginsburg talked about the worries of there is no way to get off of this. This doesn't cure everything. What if the person is cured? I think it's important for the court to note, while Mr. Donaldson was convicted of a subsequent crime, and I'm not making excuses for him, and if he would hear, he wouldn't make excuses for that, it was not a sex offense. He has never been convicted of a second offense involving children or sex or anything else. I do think that's important. The reason that they're challenging this court to overturn itself and asking it to, though, I think is important, and they're talking about workability. And I absolutely disagree that this statute is unworkable and stare decisis should be ignored. Because personally, I have worked with hundreds of sex offenders across the state, looking at their cases. I have worked with the Department of Corrections. I have worked with some attorney general's offices. I have worked with city managers, city attorneys, judges, prosecutors, and all of them are learned, distinguished people, and that's what I love about this profession, is because we have to take and analyze the situation. And in each one of those instances, it was portrayed that Palmer Law, in a brief, that Palmer Law was bullying these cities into doing what we wanted. I don't work for Palmer Law anymore, but I now work for myself, but I can tell you that is not the culture of that firm. We worked with other lawyers to look at the law, to look at the decisions this honorable court laid out and determine whether we should be here. In only one instance did we end up in a lawsuit, and it was here. So the idea that this is unworkable is just not true. The Department of Corrections presents each one of these sex offenders when they register a list, and it tells them which provisions apply to them based on it. So it's not unworkable, Your Honor.
Now, it's not your firm or Palmer Law Firm's job to make it workable, though. It's the state of Oklahoma, right?
I think it's a job of all of us to work together to make it workable, Your Honor.
But it's administered by the state.
I would agree with that.
And their counsel, the Attorney General, says it's not workable. Would you agree with that?
I would agree. That's their position today, Your Honor.
Thank you.
I think the banishment argument is very important, and as the last point, unless the court has other questions, I would submit to the court that the city's intent is even more clear to banish persons than the legislature's was. And I would point no further than the city's response to summary judgment at page 186 in the record, and it's in bold, plain language. There are hundreds of other cities in Oklahoma where Mr. Donaldson could have purchased property. I'm out of time. May I finish this thought?
Please continue.
Could have purchased property that would not be subject to the 2,000-foot residency restriction. I think that's clearly the city's intent to banish Mr. Donaldson and other people that are in similar situations.
Counsel, again, same question I asked your co-counsel. You did not present any evidence at the trial court level with regard to locations within El Reno where an aggravated registered sex offender could lawfully reside. You didn't present any evidence with regard to that.
No, we did not, Your Honor. We focused.
And I take it from your experience in representing sex offenders across the state, you're familiar with that process.
I am, Your Honor.
Is there a reason why you didn't do it here?
We were focused clearly on this residence and this house and the declaratory relief that we were seeking, Your Honor. I believe that we filed the motion for summary judgment. There was competing motions. We felt that the law was clear, especially considering the decision that the Court of Civil Appeals made in Graham and this court's decision to deny certiorari. We thought there was plenty of evidence to move forward with summary judgment, and we felt that we had the opportunity to be remanded if the court wanted to know more.
Okay, thank you.
Any other questions? Thank you, sir. I appreciate that. And we've reserved 5 minutes for rebuttal.
May it please the court. It's the city's position that he does not get the opportunity to go back on remand and get another go at presenting the record he should have made in the first place. The evidence with regard to banishment should have been put in the record when he filed his motion for summary judgment, and if we wanted to put our evidence in the record and argue about whether sex offenders are banished from El Reno, we could have done that, but that's not how he prosecuted this case, and he doesn't get to go back and have a do-over. Justice Combs, to your point, that information about the number of sex offenders living in El Reno currently is a public record that could have easily been accessed to put in this record.
It's not the number that resides there. It's what location sex offenders or locations sex offenders can lawfully reside. I'm not advocating that he should get a second bite of the apple here. More than that, I'm complaining that he didn't do it the first time, because it would have been nice to know whether or not, on the banishment argument, whether or not there legitimately is a limited area where a person currently can reside, up until the point that a daycare decides to go in within 2,000 feet, or a zoning law is changed with regard to residency, but they didn't put that on. It's not about the number of that reside in El Reno. It's about what locations might possibly be available for them to reside in lawfully.
Sure, and the city has all that information, but it's not part of this record, and he didn't request it.
And I agree it's not part of the record.
So that's a problem for him, because we don't have any evidence that he's been banished from the city of El Reno in this case, which is the first factor that this court has to look at in the Smith versus Doe case that was adopted by Starkey. That is the framework that this court told us to work under in the Starkey case.
And can you talk about, I definitely want to hear this before you finish. Can you talk about the criminal punishments that they're citing to in order to say that
Sure.
proves a punitive effect?
Sure, so 590A is where the residency requirement is at. That on its face is a civil regulation as part of SORA, which is a civil regulatory program to keep sex offenders registered. If you violate any of those provisions, then you are subject to criminal penalties, but that's a different analysis than what we're looking at today. On its face, 590A is not punitive.
Right, because if you don't do what you can't do, then you won't get punished.
That's right. And I just want to briefly touch on a couple of questions that Justice Rowe and Justice Kane asked go to some of these factors, which we haven't really gotten to dig into, but the third factor is whether the residency restriction promotes the traditional aims of punishment to the extent it justifies finding that the requirement is punitive. And with regard to deterrence, which is one of the traditional aims of punishment, the 10th Circuit said in Shaw versus Patton, and I think this goes to Justice Rowe's point, that deterrence is not unique to punishment. Any civil regulation likely has some deterrent effect, and any number of governmental programs might deter crime without imposing punishment. So as you mentioned, the OMMA is one of those civil regulatory systems. Taxes, you've got to pay your taxes, you're subject to criminal penalties. Campaign finance laws, municipal officers are subject to criminal penalties if they violate the Open Meetings Act. So there's a lot of examples of civil regulatory systems that subject you to punishment if you violate those. That doesn't mean that they're punitive on their face, nor does it mean that they have a punitive effect. And I do want to clarify that the question is not just whether it has a punitive effect, it's whether it's so punitive that it cannot be applied retroactively. And so when you're looking at the effects of it, you've got to look at those factors and balance that under Starkey. If we stick with the neutral evaluation standard, then you balance what that evidence in the record looks like against those factors to determine if there is a punitive effect. And we think when you go through, as compared to what they presented, which was nothing below, there's not a punitive effect in this case that would rise to the level of punishment. We think that the court in this case should reverse the district court, and I don't think that you should send it back on summary judgment to allow them to have a second chance at presenting the evidence they should have presented on the factors to begin with. I also don't think there's a fact question with regard to whether the park, the city of El Reno's Lake El Reno is a park. They didn't put anything in the record to dispute that. Can I finish my sentence? So we put in our municipal ordinance. That is what is the law in El Reno. They didn't challenge that. There's nothing in the record here that makes it a disputed fact question to send it back on the issue of whether this is a park. Thank you.
Thank you, and I want to thank council not only for their presentation today, but also for their briefing, which I think the court found very helpful. We will have a decision at the time that it is arrived upon. So stand by. Thank you. We'll be in recess.